Colette and Jason are staff attorneys for the Maryland Association of Realtors. You may have spoken to them if you've ever used our legal hotline, just one of the many MAR benefits. This webinar is the first in the 2015-2016 Maryland Association of Realtors Webinar Thursday series and another of the free MAR benefits. The webinar topics are a wide variety to help you work smarter, not harder, brought to you by speakers from across the country and in your own backyard. You can view the entire schedule on the MAR website under Top Destinations. A little bit about Colette. She is a native Washingtonian who earned her undergrad degree from Oberlin College and her law degree from American University. Upon graduation from law school, she clerked several years for Superior Court Judge Rhonda Reed Winston. Prior to joining MAR in January of 2006 as a staff attorney, she worked for several law firms in the D.C. metropolitan area. Her primary focuses include staffing the legal hotline, teaching continuing education courses, facilitating professional standards trainings, and working with the statewide forms committee. Jason has lived in Maryland since graduating law school in 1993. He worked for a title company as a real estate broker and developer, as a solo practitioner before being hired as a local government affairs contractor for MAR in 2008. As a broker, Jason was involved with the Anne Arundel County Association of Realtors, serving on their legislative and forms committee as well as their board. During that time, Jason was also a member of MAR's legislative committee. In 2012, Jason was hired as a staff attorney at MAR, where his primary obligations include staffing the legal hotline, professional standards training, providing government affairs support for the Bay Area and Howard County associations, respectively, and staffing the Commercial Alliance Committee. This webinar is being recorded and will be available on the MAR website. Let's begin.
Good morning, everybody, and welcome to the Contracts 101. Today we're going to be talking about the elements of contract. We're going to touch on some issues, and please feel free to ask questions as we go through, and we will just jump right in and get started. All right, so the first question we'll kind of tackle is, what is the legal definition of a contract? So hopefully everybody kind of has a sense of that. Contract is a promise or set of promises for breach of which the law gives a remedy, or the performance of which the law recognizes as a duty. All right, so if buyer and seller get together, form a contract, and let's say the buyer doesn't perform, maybe the buyer doesn't submit the earnest money deposit or something like that, that would constitute a breach of the contract, and the seller would be able to pursue a remedy. Now, there are several different types of remedies. There could be the seeking of contract damages, or there could be the pursuit of specific performance, which we'll discuss a little bit later on. The other point to make about just generally contracts is that they are governed by the common law, which essentially is case law. Right, so Maryland's highest court, the Court of Appeals, will decide a case, and that ruling, whatever that ruling is in that case, becomes the law as it regards contracts in the state of Maryland. As opposed to statute, right, so give you an example of statute, Maryland real estate licensees are governed by the Maryland Real Estate Brokers Act, which is a statute, right, so we have the difference there between common law or case law and statute, okay. So types of contracts to be concerned about, or for our purposes, bilateral contracts come into play often. A bilateral contract is a promise for a promise. It's an exchange of promises, essentially. An example of that would be, of course, the MAR contract of sale. The buyer promises to purchase and pay for property. The seller promises to convey the property, convey title. So there's a promise in exchange for a promise. Unilateral contracts is another example of contracts that would be relevant here. The definition of a unilateral contract is where a party makes a promise to induce a second party to do something, and a good example of that would be the listing broker's offer of compensation in MRIS or whatever multiple list service there is, and then the broker who brings the buyer that action creates the unilateral contract, right? So types of contracts there that we're concerned about. And of course, in the context of real estate, we have the brokerage forms, so the listing agreement, the exclusive buyer-tenant representation agreement. Of course, we have the contract of sale. There are option agreements out there. An option agreement, for example, is where the owner gives buyer or tenant the right to buy or purchase the property at agreed upon price within a certain period of time, and the buyer or tenant pays what's called an option fee. And then, of course, we have leases, and MAR recently created the dwelling lease template. We get a lot of questions about why it's titled template. The reason is because it is a model, right? So landlord-tenant law is governed in many instances by local law. And so the dwelling lease template is styled that way to give brokers an opportunity to modify the lease so that it complies with local law. Of course, once that lease has been reviewed by either broker counsel or board counsel, then you can remove the template and it'll just become the dwelling lease for that jurisdiction. So the reason again for that is because local law varies when it comes to landlord-tenant law, and we want to make sure that the lease could be modified to comply with local requirements. Okay. So moving on to the elements of a contract, of course, we have offer and acceptance, and delivery is key, which we'll talk about. There's
Colette,
also, yes.
Can I interrupt for just a second?
Sure.
You're not seeing your slides yet. Are you going to put them up, or are we not to that point in your presentation yet?
Oh, no, they should be up. Now, I'm not sure why you're not seeing them. Wait, let me see. Can you see them now?
Yes, we can see them now. Great.
Okay,
thank you.
Okay, great. I'm sorry about that. So yes, so we're on the topic of elements of a contract. We've got offer and acceptance and delivery, and we'll talk about that. Mutual assent, the parties have to agree to the material terms, so we'll talk about that. Consideration, of course. The parties have to be legally competent. There must be consent, and of course the contract must be for a legal purpose, right? So any agreement that's entered into that's illegal, it would not be obviously enforceable. Okay. So the first concept, the offer. Of course, the point about the offer, I think, that's important is to make sure that you're clear that the terms of the offer have to be definite and specific, right? And we'll talk about that when we get to the material terms or the mutual assent. But the offer, of course, it has to be definite and specific, and it has to be communicated, obviously, to the offeree. So the buyer would be submitting the offer to the offeree, which would be the seller, and it has to be communicated to the seller. Okay. Offers obviously can be terminated, right? So ways that the offer can be terminated might be by revocation. So the important point here is that the offer, an offer can be revoked, right, at any time, or withdrawn is another way to say that, revoked or withdrawn at any time before it is accepted, right? So example would be, let's say the buyer submits an offer today, and the seller is considering the offer, and let's say the buyer agent takes the buyer out to see another property. The buyer really likes the second property. As long as the seller hasn't accepted the first offer, then the buyer can go ahead and submit a revocation and a notice essentially revoking the offer, and then that offer would essentially become dead, and the buyer could go ahead and submit the offer on the second property. So the offer could be terminated if it were revoked by the buyer. Another example of the offer being terminated is lapse of time. So if the offer is sitting out there for an inordinate amount of time and the seller never accepts it, then it would be terminated by lapse of time. Okay. So offers in real estate, so for our purposes, what should an offer to purchase property include? It should definitely include a description of the property, okay? It should include the price. So these are all sort of material terms that we'll be talking about a little bit later. It should include the price. It should include the settlement date. The financing terms are material, so the interest rate, the term of the loan, all those things need to be specified in the contract. And then finally, the names of the parties. So for example, if the buyer's name was, or if the buyer inserted as their name, an LLC to be created within, 3 or 4 days, that would not probably be sufficient in terms of a name for the buyer. So it has to be a definite name associated with the parties. Then we have counteroffer. So the thing to take away about the counteroffer is that once the offer is countered, the initial offer is considered dead, right? So it cannot be accepted after it is countered unless it is revived by the buyer. Okay, so a counteroffer is a rejection of the initial offer, and essentially it's considered to be a new offer. And so if the seller makes a counter on the buyer's offer, then the buyer would then have to agree to essentially the new offer. Okay. So the question is, does a counteroffer have to be in writing? So for our purposes, for real estate and any real estate transaction, the counteroffer does in fact have to be in writing. Okay. Now we get on to the second element of acceptance. All right. So a promise by the offeree to be bound by the exact terms proposed by the offeror. So example of that would be the buyer submits the offer. The seller accepts the offer as submitted. All right, so that would be acceptance. All right, the acceptance must be communicated to the offeror or to the buyer for our purposes. And then, of course, there has to be delivery, the element of delivery. Okay, so delivery is defined as the communication of acceptance, which may be accomplished by acts as well as by words. And a lot of people are under the impression that you must deliver the fully executed documents before there's delivery. But remember that delivery is the communication of acceptance, which may be accomplished by acts as well as by words, right? So here's the scenario. If the listing agent contacts the buyer agent and tells the buyer agent that the seller has signed the offer and that we have a contract, then delivery has in fact occurred, even though the fully executed documents haven't been delivered. So remember, if you go back to that, delivery can be accomplished by acts as well as by words. Okay. So date of contract acceptance, right? So it's the date, the definition of the date of contract acceptance is the date when the last required named party has executed or initialed any and all provisions of the sale and any amendments or any addenda associated with the contract. So again, it's the date when the last required named party has executed or initialed any and all provisions of the contract. Okay, so that's the date of contract acceptance. Typically, the question will be, well, can the agent, if it's missing, if the last person didn't insert the date of contract acceptance, can the agent insert it? And technically, there's nothing that says that the agent can't insert the date of contract acceptance. The key, though, is to make sure that the date is accurate. And of course, the best practice would be to ensure that it's the parties that actually do it. But can the agent do it? They can, as long as that date is accurate. Okay.
Hey, Colette.
Yes.
A quick question on how do you write in a contract? How do you write a contract when an offer expires?
How do you write it? Well,
in a contract when the offer expires, or are you able to?
No. I mean, if the offer is revoked or expired, then the seller, if it's on that side of it, then it would have to be a new contract or a new offer submitted, right? So once the offer is dead, essentially, then it would have to be revived by the buyers if they submit a new offer. Does that make sense?
Yeah, and then a follow-up is if you could define what that reasonable lapse of time is for contract purposes.
So lapse of time, so typically, I would, it's my understanding that if the offer gets submitted, let's say, to the seller, and maybe the seller is out of town, right, and maybe doesn't accept the offer for several months, I think a court would maybe determine that the elapse of time, the offer's been sitting out there for too long. Okay, does that make sense?
Yes, absolutely. So, and then a follow-up was, can an offer be withdrawn after it's accepted, but before the acceptance is delivered to the buyer?
So once the offer is accepted, it cannot be revoked. Okay, so once the seller accepts the offer, then essentially what you have is a contract, and the offer at that point doesn't really exist anymore because you now have the creation of a contract, so it cannot be withdrawn or revoked at that point. Okay.
And finally, can you state in a contract when an offer will expire? So, for example, 2 weeks?
Yes, you can insert terms in the offer that says, you know, hey, seller, you have 48 hours to accept the offer. If you don't accept the offer within that time frame, then it's considered revoked and essentially dead. So yes, you can include terms in the offer that put a time limit on the seller's, you know, the time the seller has to consider the offer. Okay.
Thank you.
Make sense?
Uh-huh.
All right. All right, so we talked about the agent inserting the date of contract acceptance, and we said, of course, the best practice is for the parties to do it, but if the agent does do it, they want to make sure that the date of contract acceptance is accurate, okay? And it's important, right, because if you don't have the date of contract acceptance inserted, then a lot of the other conditions, there's no time frame upon which to base that. For example, you know, if the contract is contingent on a home inspection, and you know the buyer has X amount of days from the date of contract acceptance to perform the inspections, but there's no date inserted there, then obviously that's going to be a big issue. So the date of contract acceptance is key. It needs to be there on the last page of the contract, and it needs to be accurate. Okay. So offer and acceptance, and we get to this concept of mutual assent or meeting of the minds, right? So there must be, for our purposes, a complete agreement between the parties about the purpose and the terms of the contract, right? So again, mutual assent, complete agreement between the parties about the purpose and terms of the contract. One question that comes up often is, well, what happens? Is there a contract if they're missing initials from the bottom of the page, or if the bottom of the page of the disclosure is not signed? I mean, I think I would say if they're missing initials from the bottom of the page, that may not affect the validity of the contract. However, if the initials are missing from a provision of the contract, then that actually could call into question the validity of the contract, right? So, I mean, for our purposes, we do want to have it be a best practice to make sure that the parties sign off and initial in all places where they're supposed to. So the idea of the mutual assent also brings into play what we say are discussion of material terms. So in contracts, enough of the essential terms of the contract must be provided to make it capable of being enforced. So examples of material terms for our purposes would be a description of the property, right? So the address might be sufficient, or if you may need a more definitive definition if it's unimproved land. The names of the parties would be material. The price obviously is important and material that would need to be inserted. The financing terms, the settlement date. So all of those aspects of the contract would be considered material, and therefore they would have to be agreed upon by the parties in writing to be considered a binding agreement. Okay. If the buyer is unidentified, is there a contract? So again, the names of the parties are material terms. So if the buyer is not identified, then you likely don't have a valid contract. Okay. All right, another element of contract formation is consideration, right? So the legal definition of consideration is something of legal value that's offered by one party and accepted by another as an inducement to perform or to refrain from some act, right? So for our purposes in real estate transactions, the consideration is going to be the purchase price. That's the price the buyer agrees to pay to purchase the property. So that would be the consideration, right? What about the earnest money deposit? Is an earnest money deposit required to form a valid contract? So a lot of people think that the earnest money is actually the consideration, but it's actually the purchase price. Earnest money is simply a showing on the part of the buyer that they are serious about moving forward, right? But as far as the elements of consideration, that would be satisfied by the purchase price being paid by the buyer, right? Going on to the legally competent party. So all parties must have legal capacity. They must be of legal age and have the mental capacity to understand the consequences of their actions. You have to have legally competent parties in order to enter into a valid and legally binding agreement. Okay. And then, of course, there has to be consent, right? So the contract has to be entered into as a free and voluntary act. Examples of situations where the contract might be voidable would be mistake, might be misrepresentation if there is misrepresentation of a material fact, and that could cause the contract to be voided. If there's fraud involved in the scenario, the contract could be voided. If there's undue influence or a party has entered into the contract under duress, then that would deprive the person of their ability for the scenario to be voluntary and could cause the contract to be considered voidable, right? So the key here is free and voluntary act of each party constitutes consent, right? And then finally, the contract has to be for a legal purpose, right? So we wouldn't say that a contract to commit murder would be valid, right? So the contract has to be for a legal purpose, cannot be to agree, or the parties are agreeing to do something that would be illegal. That would not be a valid contract. All right, so.
Colette, a couple of questions.
Sure.
One question was, is the name of an LLC considered a valid name of a buyer or a seller?
Yes. Right, so if it's Massengale LLC or Brand LLC, yes, then that would be considered a name. So that would be sufficient for purposes of the material terms being satisfied, yes.
Okay. And then a question is validity in question if a contract is missing an addendum, for instance, the Maryland jurisdictional addendum?
Yes, that would absolutely cause the validity of the contract to be in question, right? Because remember, excuse me, the parties have to agree to the material terms. So if you've got provisions in a jurisdictional addendum that have not been agreed upon, and let's say, you know, the parties were intending that they be agreed upon, but they weren't, they're missing from the contract, then yes, that's absolutely going to call into question the validity of the contract. Yes.
Okay. And then I think we have a contract acceptance question. So the question is, if the contract is delivered on a date later than the date the last party signed, what is the date of the contract? Is it the signed date or the delivery date?
It's the date. The date of contract acceptance, right, is the date the last party signed, okay? That's the date of contract acceptance. All right, so just to be clear about that, it's the date the last party initials and signs where they're supposed to, okay? Make sense?
Yep, absolutely. So,
okay.
And then what about sellers inserting the phrase owner of record as seller when they are not the record owner on SDAT or in the land record?
Now that could be an issue. Owner of record, that could be an issue, and especially if that's not the person who appears on SDAT's website. So the names of the parties need to be sort of clearly delineated. If it's not, that could be an issue, could cause the contract to be considered not valid. Okay.
Yep. There also seems to be a question on talking about consideration being the purchase price and talking about whether EMD is actually required or not.
So the earnest money deposit isn't required, right? So if the parties agree that, they're going to settle on what, today or tomorrow, whatever, and they've agreed on a purchase price, then that would be a valid contract. So in other words, you don't have to actually have an earnest money deposit, as part of the contract in order for it to be considered valid, as long as there is a purchase price that the parties have agreed to, right? So again, the earnest money deposit is there simply as a showing on the part of the buyer that they are serious about moving forward, but it's not required. Now, obviously, it's industry practice or industry standard, and I'm not aware of any jurisdiction that doesn't have the buyer submitting an earnest money deposit, but for purposes of contract law, it's not required. What's required is consideration, and if there's a purchase price involved, then the purchase price would be the consideration, which it is in every instance. Okay?
Mm-hmm.
Makes sense?
Got it. Yeah, absolutely. A couple more.
Okay.
Why is it important for the interest rate to be put in the contract? It changes often, and how can this affect the contract?
So the interest rate is part of the financing terms, right? And so as I was saying earlier, the financing terms are material, right? So again, the parties are bound by the essential terms that they agree upon. So the financing terms are part of the material terms. They have to be specified. Again, interest rate. Now you could, it could be that you have, for example, interest rate, you might say not to exceed 6% or something like that. That's okay. But if you had something like to be determined or market rate or something like that, that in our view is not sufficiently specific. And so the argument could be made that we don't in fact have the material terms of the contract agreed upon because that term is not specified, and that would call into question the validity of the contract. So again, the financing terms are material terms. And so in order for a contract to be considered legally binding and valid, the material terms have to be agreed upon. If anything is left out as far as financing, that could cause the contract, the validity of the contract to be in question. Does that make sense?
Yep, it sure does.
Okay.
I think we got some other questions, but I think that you're going to touch on them soon, so I'm going to hold off on those for the moment.
Okay.
Okay.
All right, so a contract is valid when it meets all of the essential elements that make it legally enforceable. So again, it's really important to understand that the material terms of the contract have to be agreed upon by the parties in writing, okay? A contract is void when it has no legal force in effect, right? So let's say the parties use the MAR contract and the buyer didn't show up at settlement. Okay, so the seller could submit a notice terminating the contract, and that would make the contract void. All right, so it would no longer be have legal force or effect. A contract that is voidable can be rescinded or disaffirmed by one or both parties based on some legal principles. So here's an example. So let's say the settlement date is today, or no, let's say the settlement date was Monday, and let's say buyer didn't show up. Right, so at that point, or come Tuesday, 12 a.m. on Tuesday, the contract is considered voidable, which means that a party has to actually take some action to terminate it. So it's not automatically void once the settlement date passes. The party or either party actually has to take action. Usually it's notice of termination or whatever it is to actually void the contract. And then it would have no legal force in effect. Is a contract with a minor voidable? Yes, that's an example of a contract that's voidable. Okay, so yes, that would be potentially a contract that's voidable. What about a situation where a seller makes a material misrepresentation concerning the property? Is this an example of a voidable contract? So yes, so anytime you have the element, there's evidence of there being a misrepresentation of a material fact, or anytime you have a situation where there's evidence that fraud has occurred. And then again, the difference between misrepresentation and fraud is intent. But anytime you have evidence of those kinds of issues arising, then yes, the contract could be voidable. The court could void the contract. Okay, so that would be the answer there would be yes. It's potential for that to be voidable. What about an oral agreement? Is an oral agreement to purchase property enforceable? So the answer there is no, right? So for real estate contracts, must be in writing. They must satisfy something called the Statute of Frauds. An oral agreement to purchase property would not be enforceable in a court in Maryland. So there you go, the Statute of Fraud. So that's a requirement under Maryland law that certain kinds of contracts, including real estate contracts, must be in writing, contain the signature of the parties to be charged, and again, we get back to that same point about material terms or essential terms. The essential terms must be specified to be enforceable in a court of law. So that's the Maryland Statute of Frauds, and real estate contracts come in play when you're dealing with Statute of Frauds, right? So they have to satisfy the Maryland Statute of Frauds. What about equitable title? What the heck does that mean? So once the real estate contract is formed, the buyer doesn't actually have title, right, because settlement hasn't occurred and the deed hasn't been transferred. But buyer does have an insurable interest, and we call the interest that buyer has once the contract is formed, we call that an equitable interest or equitable title, right? So that's where that term comes from. What about assignment? Can the contract be assigned? What do we mean by that term? So an assignment is essentially a substitution of the parties, the transfer of the rights and duties under the contract. The rights and duties under a contract may generally be assigned to somebody else unless the contract forbids it, right? So contracts can be assigned unless the terms of the contract or provision of the contract says that it cannot. But what about the MAR contract? What does the MAR contract say about assignments? We'll see. Essentially, the MAR contract says that it cannot be assigned unless both parties agree, all right? Non-assignability, paragraph 54. This contract may not be assigned without the written consent of buyer and seller, okay? What about discharge? A contract is discharged when the agreement is terminated, right? So agreement can be terminated by both parties. So if both parties agree, then you would have mutual agreement. Both parties would execute the mutual release of obligation under contract, or the contract could be terminated by operation of law, right? So what do we mean by operation of law? So an example would be the voiding of the contract by a minor, right? As a result of fraud or due to an expiration of the statute of limitations, or because the contract was altered without the written consent of all parties. All right, so those are examples of situations where the contract would be discharged by operation of law. All right. Breach of contract. All right, so breach of, yes.
Can you mind going back for a second? I've got a couple more questions on.
Sure.
One question on counteroffers. So if a verbal is not binding, why do I run into agents who want to counteroffer verbally instead of putting it in writing? Is one way it's asked. And
so let me tackle that. So of course, you know, up until the time where the parties are, you know, have everything in writing, there's negotiation, right? So the verbal discussion about the terms of the contract would be considered negotiation, but of course negotiations are not binding on the parties. It's not until the negotiations are solidified and, you know, put down in writing into the form of an offer that we get into, you know, the real aspect of whether or not you've got an enforceable contract. But anytime you've got sort of the back and forth orally, that would be considered negotiations. And of course, negotiations aren't binding until everything is put in writing and signed off on by both parties.
And I guess the follow-up, or a slightly different way of phrasing it, was you mentioned that counteroffers must be in writing. I've been taught not to have the seller write anything on the offer or to do any strikeouts. How would you recommend the seller put the counteroffer in writing?
Well, I mean, you can certainly. I mean, if the offer comes in, let's say, let's say the offer comes in at $450,000, the price of $450,000, and the seller wants to counter the price, and let's say they will accept $455,000 or $460,000, then certainly under contract law, you could, or the seller could strike the price that was initially offered, strike through the price, put the price that they want. So $460,000 would be inserted. The buyer would initial the change. I'm sorry, the seller would initial the change, and then it would go back to the buyer. And if the buyer agreed to the change in price, then they would initial it, and then the new price would be the $460,000. So certainly under contract law, striking through the initial offer and inserting whatever terms the seller wants to insert would be a way to do a counteroffer. Another way to do it would be, in the form of an addendum. But it seems to me the striking and initialing would be a way to make the counter.
Okay. We've had also a couple questions on the assignability as well. So can you create assignability by noting it in an addendum and having all parties sign off on it?
Yeah, so if the parties wanted to be able to assign the contract, then the first thing they want to do is go to the assignment or the non-assignability provision in the contract. And if they want to strike through that and then, create an addendum that says what they want it to say with regard to assignment, then they could do that. And then if both parties agree to that change with regard to assignability, then that new provision regarding assignment would become part of the contract. But you first want to address what the contract already says so that you don't have anything conflicting. Okay?
Right. So, and there was a follow-up. Could you make a contract assignable simply by crossing off paragraph 54 on the MAR contract and both buyer and seller initial that?
Well, I think that sort of leaves a gray area, right? So if you want the contract to clearly be assignable, the best way to do that is to state it, that the parties agree that the contract can be assigned, right? So just striking through the assignment provision, I think, is going to create a gray area, because then you don't really know what the parties want with regard to assigning it. So I think the best way is to address it in writing and not just sort of cross it out and leave it up to, I don't know, whomever to decide what the parties actually meant with regard to assignment. Does that make sense?
Absolutely, yeah. Perfect.
Okay. All right, so any other questions?
We'll have some, but I think, again, you may address them here shortly. So.
Okay, all right, so breach of contract. All right, so breach of contract is a violation of any of the terms and conditions of the contract. And I think it's important to make a distinction, and we'll get to it a little bit later, between a breach of contract, which again is a violation of the terms and conditions of the contract, and contingencies and the inability to remove a contingency. There is a distinction, and I'll discuss that in just a little bit. Okay, so again, the breach of contract is a violation of the terms and conditions of an offer, of the contract, excuse me. So for example, let's say the parties agreed that there was going to be an earnest money deposit that was submitted by the buyer on the date of contract acceptance, and let's say the buyer doesn't submit the earnest money deposit. That would be considered a breach of the contract, because the parties agreed that the buyer would do it and the buyer failed to do that. That's a breach of the contract, all right? What about damages? So breach of contract may entitle the non-defaulting party to damages. So what do we mean by damages? So for purposes of breach of contract, you're typically going to have two types of remedies. One would be contract or money damages, and the other would be an equitable remedy, which we would call specific performances. So you're either going to have money damages or you're going to have an equitable remedy of specific performance. Okay. So there's a specific performance is essentially where the buyer goes to court. It would be an example. The buyer goes to court and asks the court to force the seller to convey the property as specified in the contract. All right. All right. So earnest money, and what if the title company is holding the deposit? So typically, you know, you have a situation where usually it's the broker, the buyer broker who's holding the earnest money deposit, but certainly the parties can agree on whomever. It could be a third party, not the broker, holding the earnest money deposit. And in some instances, the parties might agree that the title company will hold the deposit. And the point here is just to make sure that, remember, title companies are not bound by the Brokers Act, right? So if it's the broker who's holding the deposit, then the broker is bound by the deposit provisions of the Brokers Act. So there are certain things that they must comply with. If a title company is holding the deposit, and let's say a dispute happens, then the parties are going to be subjected to whatever the title company's policy is. So it would probably be a good idea for buyers and sellers, if they're going to have a title company hold a deposit, to agree on what will happen if there is a dispute, right? So they should have some sort of arrangement up front so that they're not sort of left to whatever the title company's policy is. Is done. All right, so contingencies, so just kind of briefly, is an additional condition that has to be satisfied before the sales contract is fully enforceable, right? So various types of contingencies out there. There could be home inspection contingency or financing contingency, you know, what have you. So third-party approval contingency, short sale contingency. So those are all examples of contingencies. And again, it's additional conditions that must be satisfied before the contract is fully enforceable. So this brings up, again, here we go to the difference between breach of contract or default and the failure to satisfy a contingency. So let's go into that in a little bit more detail. So here's the deal. So what if a buyer makes a good faith effort? So let's say the contract is contingent on financing, and the buyer makes a good faith effort to obtain financing, does everything they're supposed to do in a timely manner, but ultimately they're denied financing. Would that be an example of a breach or a default, or would that be simply a failure to satisfy the contingency? So the answer is that that would be a failure to satisfy the contingency. That's not a breach. And if the parties use the MAR contract, you'll note in paragraph 10 that if the buyer makes a good faith effort, does everything they're supposed to do, and is ultimately denied financing, then they submit to the seller, along with the notice of termination, a copy of the denial letter from the lender, and then they're entitled to the return of deposit. So that would be an example of simply a failure to satisfy the contingency. That's not a breach of the contract, right? On the other hand, if the buyer fails to apply for financing or fails to submit the earnest money deposit, then that would be a default. That would be a breach of the contract, and so the seller would be entitled to pursue contract damages or specific performance or something like that. All right, so that's the difference, and hopefully everybody sees the difference there between breach of the contract and the failure to satisfy or inability to satisfy a contingency. Just a note about, since we're on breach, so for, let's say, you know, seller wants to go to court and sue the buyer for breach of contract, the seller would have 3 years to pursue that claim, right? So the statute of limitations for breach of contract claims in Maryland is 3 years, right? So they have 3 years to pursue the action in a court in Maryland.
Colette,
yes.
One question was, what is the Brokers Act?
Oh, the Brokers Act. All right, so the Maryland Real Estate Brokers Act is statutory law, and that law governs the obligations of real estate licensees in Maryland, right? So all of your agency requirements, all of the handling of the security deposit, all of your discussion about fiduciary responsibility to the client, all of those things, your licensing, how you go about getting your license, you know, your education requirements, your CE, all of those kinds of issues are dealt with in the Maryland Real Estate Brokers Act, which is contained in the Business Occupations and Professions article of the Annotated Code of Maryland. So that act governs the responsibilities of real estate licensees in the state of Maryland. Okay?
Yep, perfect.
All right, so a bit about amendments and modifications, just to be aware. So an amendment or modification obviously is a change to the existing content of the contract. The thing to remember about that is simply, you know, once the contract is formed, the terms that the parties agreed to are what is binding, right? But outside of that, so let's say the buyer wants to change a term of the contract, maybe they want to extend the time for obtaining financing or what have you, then of course the way to do that is be an amendment. So they would, you know, write on an addendum, you know, can we change or request of the seller, let's change the settlement date or let's change the time frame for obtaining financing. And the seller can agree to the change, right? So if the seller agrees to the change, then that new term, that becomes a new term and becomes part of the contract. If the seller doesn't agree to that request, then the underlying terms of the contract remain in full force and effect, right? So amendments are only essentially binding on the parties if they are agreed to by both parties in writing, right? All right, and of course, addenda, we have tons of addenda. You've got, you know, the financing addenda. Those are all examples. The home inspection, those are all examples of addenda. Any provision that's added to an existing contract. So you've got the contract of sale with all 55 or 56 provisions. And then, of course, the home inspection contingency, that would be an addenda. The seller financing would be an addenda. So all those are just examples of addenda that become part of the contract, all right? So be aware of creating an internal inconsistency. And so I raised this point because, remember, you've got all the addenda, right, that could become part of the contract. You've also got local board addenda. You've got jurisdictional addenda, jurisdictional addendums, and other terms, other addenda. You want to make sure that, for example, let's say the parties want to make the contract contingent on a home inspection, and let's say, you know, the property is located in Prince George's County, and so the parties include the Prince George's County jurisdictional addendum. Well, remember, make sure the parties go through the addendum, because the Prince George's County jurisdictional addendum might also contain a provision that discusses inspection. So you want to make sure that the jurisdictional addendum that contains the inspection provision doesn't conflict with maybe the fact that the parties included the MAR property inspections addendum. So you just want to make sure that there's no conflict, because if there is a conflict, then that may be an issue. You know, if there's no superseding language, typically you'll see in some of the MAR contract addenda, it might say something like, you know, this language in this addendum supersedes any conflicting language in the contract. So that'll tell you then that addendum is controlling if there's a conflict. But if you don't have that language, then you've got two competing provisions, then the parties are going to be an issue, because there's nothing that specifies what actually is going to be controlling. So be aware of that. Look out for competing or conflicting terms and jurisdictional addenda and things like that. What about time is of the essence? So this is not inferred. The time is of the essence provision is the very first provision on the MAR contract. It basically says, so let's just see what that says. It says, you know, if the parties don't agree or don't perform as they're supposed to, then the non-defaulting party, or if they don't perform within the agreed upon time frame, then the non-defaulting party can send a notice terminating the contract, right? So the time is of the essence provision in the MAR contract, for example, is the very first provision on page 1 in the box, right? And what it really means is that the time frames, the settlement date, you know, the time frame for doing the inspection, what have you, obtaining financing, all those time frames are firm. So if the parties don't meet those time frames, then the other party or the non-defaulting party has the ability to, you know, terminate the contract. All right. So there's the language there for in the MAR contract. It says, and again, this is the language in the box, the failure of seller or buyer to perform any act is provided in the contract by the prescribed date or time is considered a default, and the non-defaulting party, upon written notice to the defaulting party, can declare the contract null and void. Right? So there it is. And of course, it says deposits should be disbursed in accordance with the deposit paragraph. Right? Just a note about the unauthorized practice of law. Just remember, the best practice would be to have the parties or their attorneys, draft any addenda or draft any amendments or any other provisions that they want to be a part of the contract. And certainly, you don't want a situation to arise where an agent or a broker wrote something that the parties wanted them to write, and then, comes down later down the line that that's not what the parties intended. So the best practice is to let the parties or their attorneys draft any addenda or any provisions of the contract, right? And just a little bit on disclosures, as far as the contract is concerned, disclosure, disclaimer, whether the party, whether the seller is disclosing or disclaiming, they must disclose any known latent defects. And again, it's the seller's obligation to disclose any known latent defects. Latent defects are defined as any material defect in the property that's not visible and that could pose harm. What should the seller do if the seller is disclaiming and they're not aware of any latent defects? Then they should insert none. That's the best practice, so you avoid maybe it would look like maybe the seller missed that, so you do want to make sure that they insert something there on page 4, and then make sure also that the entire 4-page disclosure disclaimer statement is provided, even if the seller is disclaiming, because remember, the first page of that document is the notice, is essentially informing the parties of what their rights and obligations are under that law. So the entire 4-page document should be sent there. The federal lead-based paint disclosure and Maryland disclosure, just a little bit about that. Now, remember, these provisions are discussed in the contract. The federal lead paint law or federal lead disclosure applies to residential properties that were constructed prior to 1978, right? So any property that was constructed residential prior to 1978, you want to make sure that you have included the federal lead disclosure and provided the pamphlet, right? The Maryland disclosure should also be provided. If you don't know what the buyer's purposes are, if the property was constructed prior to 1978 again, and it's possible that the buyer is going to use that property as an investment property or a rental property, then they should be aware of the Maryland Lead Poisoning Prevention Program Act, which requires that any rental properties that were constructed prior to 1978 have to be registered with the Maryland Department of the Environment, right? So again, the key here is that the law applies to properties that were constructed prior to 1978, okay? The agency disclosure, just a point about the agency disclosure, because of course you cover that in your agency class, but just remember the agency disclosure is part of the file, right? So you make your disclosure as required under the agency provisions, and then you put the copies of the disclosure in the file, okay? And then just a little bit about material facts. Of course, they will come up throughout the course of the transaction. What are they? Material fact is defined as anything that will affect the value of the property or the buyer or tenant's decision to purchase the property or on what terms to purchase the property, right? And it is the licensee's, the real estate licensee's obligation to disclose material facts that they know or should know that relate to the property, all right? So we saw earlier when we were talking about latent defects, that's the seller's obligation to disclose known latent defects. It is the licensee's obligation to disclose material facts that they know or should know that relate to the property. All right. All right, so just some issues just to point out. The financing terms, we talked a little bit about that and making sure that they are specified. They are considered material terms. They have to be specified in the contract. Also note that the buyer is obligated to make an application, one application, right? They are obligated to obtain the financing as specified in the contract. Now, can they pursue other financing? Yes, as long as it has no detriment to the seller, and they can pursue alternate financing, and that's where you have the alternate financing provision in the MAR contract.
Hey,
Again, just a little bit, reiterate again, under the financing terms, the loan details need to be specified, so things like TBD or market rate are not sufficiently detailed and could cause the contract to be considered invalid. All right. When buyers offer different financing, so yes, alternate financing, the buyer can pursue alternate financing as long as, again, there's no, the seller is not going to be affected by that. So just a little bit about as-is transactions. You want to make sure that if the seller's intent is to sell the property as is, they may state that in the MRIS or a multiple list. They may state that they are selling the property as is. You want to make sure that the as-is addendum is included in the contract. If it's not included, even though the seller is marketing it as is, you still have the property condition provisions. And so if you don't include the as-is addendum, then the seller is still obligated to convey the property in, however whatever condition is stated in the contract. Okay. Does the buyer have the right to do a walkthrough if it's an as-is transaction? The answer is yes, if it's the as-is, MAR as-is addendum that's used. What kind of inspections can the buyer conduct in an as-is transaction? Well, if the parties agree to paragraph B of the MAR as-is addendum, then the buyer can do whatever inspections the buyer chooses to do.
Hey, Colette?
Yes.
There's a question regarding the termite clause. If an as-is document's included, does the termite clause not apply, or does it supersede the as-is?
All right, so if it's the as-is and you've got the as-is addendum included, then the first paragraph of the MAR as-is addendum essentially deletes the termite provision. All right, so it says something like, termite provision is hereby deleted from the contract. So the terms of the as-is addendum delete the termite provision and any other provision in the contract related to condition. Okay.
Yeah, and I want to go back for just one other question.
Sure.
As a broker, if the seller refuses to sign a release based on the buyer's failure to satisfy a contingency, what's the broker's position in releasing the deposit? The seller was provided the denial letter but refused to sign the release.
All right, so if the seller is refusing to sign the release, the deposit agreement, is that what it is?
Yes.
So the next step then would be, for the parties themselves, the next step would be mediation, right? So that's the party's next step. The broker has a couple of options under the Brokers Act with regard to deposit. So if the broker believes that, if this was inability of the buyer to satisfy the contingency, then one option that the broker has under the Brokers Act is to do something called the 30-day letter. So what that is, the broker would send out a letter to both the buyer and the seller stating who they believe is entitled to the deposit, and if they don't get a written protest from either party, then they can go ahead and disperse the deposit. But that's something that has to be done in accordance with the particular provision in the Brokers Act, right? So the broker has certain options as stated in the Brokers Act, but the party's obligations, if the seller refuses to sign the release deposit agreement, their next step would be mediation. Make sense?
Yep.
Excuse me. All right. All right, so the question is, what if the as-is addendum was not used? So what if the as-is addendum was not used, but the MLS remarks state that the property is being sold as is? So really the point here is to be clear that it's the contract terms that are controlling. So you want to make sure that the as-is addendum is included if the seller's intent is to sell the property as is. The termite provision, paragraph 18, or the wood-destroying insect provision. So what are the seller's obligations specifically? The seller is obligated to treat any present infestation and to repair any damage caused by present or prior infestation. That's the seller's obligation. Other question that typically comes up is this provision negotiable? Can the parties strike through it or change it in any way? And of course the answer is yes. For example, if the seller wants to change the rate, I think, they have to make the repairs up to a certain percentage. They can change that percentage. As long as any change to the provision is agreed to by both parties, then yes, that provision can be changed by the parties.
Colette, a couple of follow-up questions on as-is as well. So,
okay.
Does the as-is addendum prevent a buyer from even asking for repairs, or do they only have the option to void the contract?
So the way the MAR as-is addendum is written, the buyer simply has the right to inspect. All right, and if they are dissatisfied with the results of the inspection, then they have the right to terminate the contract. And again, that's if the parties sign initial paragraph B of that addendum. Now, a buyer who's asking for repairs, that's essentially going to be, we talked about earlier, adding a new term to the contract, right? Because the as-is addendum as written does not allow the buyer to request repairs. If the buyer wanted to request the repairs, after the contract was formed with the as-is addendum as part of the contract, then that would be the introduction or constitute the introduction of new terms, right? So the seller could then, say yes or no to that request, quote unquote. But if the seller says no to that request, the underlying terms of the contract remain in full force and effect. Okay, so that would essentially be the introduction of a new term that would have to be agreed upon by the seller. If the seller doesn't agree to it, the underlying terms of the contract remain in full force and effect.
Okay, and then the question is, doesn't the MAR contract say the property sold as is?
No, well, it says, if you're referring to paragraph 21, it says the property is going to be conveyed to the buyer, right, broom clean, and it's substantially the same condition as existed on the date of contract acceptance. You also have the termite provision that's part of the contract, right? So if you don't include the as-is addendum, then the seller is conveying the property broom clean. They have to repair any termite damage. So no, I mean, I think there are some property conditions that that may come into play, essentially, if the as-is addendum is not part of the contract. Does that make sense?
Mm-hmm. And then finally, is the seller responsible for any conditions of the appraiser for an as-is sale?
Well, that might depend on if there's, let's say there's like a financing contingency, maybe there's VA financing or FHA, and maybe in one of those, via one of those addenda, the seller, may have agreed to do some lender repairs, but outside of that, the seller, if it's an as-is transaction and there's no other addenda that specify what the seller has agreed to, then the seller's not obligated to make any repairs. Does that make sense?
Uh-huh. Yep.
Okay.
And then for an estate sale, is the as-is still required?
So again, if it's an estate sale, then the seller wants to include the as-is addendum because, even if it's an estate sale, if the parties use the MAR contract, for example, and they don't include the as-is addendum, even if it's an estate sale, there's, paragraph 21 and there's the termite provision as well. So in an estate sale situation, whenever estate sale would have you, if the seller, whoever that might be, personal representative or trustee or whomever, if they want to convey the property as is, they need to include the as-is addendum.
Okay, thank you.
Okay.
Mm-hmm.
All right, so we talked about the wood-destroying insect provision. Is it negotiable? Yes. What about the home inspection provision? The MAR property inspections addendum, there's still some confusion about what the heck paragraph 4B. So paragraph 4B is a walk-away provision, right? So that essentially says that the buyer can walk away if they're dissatisfied with the results of any inspections that the parties have agreed to. So I think the confusion comes in with that language there. So essentially, here's kind of in a nutshell how it works. So let's say the offer is submitted and the buyer has initialed paragraph 4B of the property inspections addendum. So that's part of the contract, and that goes to the seller for consideration. So if the seller accepts the offer as submitted, then all they have to do is initial paragraph 4B, initial all the other, provisions of the contract, and then you have a contract. And 4B is part of the contract. But what if the seller doesn't want to agree to have 4B be part of the contract? So what would the seller do? The seller would then, and of course, the buyer had initialed that. So what the seller would need to do is strike through paragraph 4B, initial it, and then that would have to go back to the seller, go back to the buyer to be initialed. So both buyer and seller would have to initial the strike through. So that's really what's required there. And then once that's done, then paragraph 4B essentially would not be part of the contract. Does that make sense? All right. The other area that comes up is, what if the parties continue negotiating outside of what the inspections addendum allowed? And so again, something like that happens, then you get into a gray area, right? Because the terms of the property inspections addendum specify, what the time frames are for the negotiation and all of that. If the parties go outside of that, then they're going into a gray area. If they're not able to come to a resolution about that, then the next step would be mediation. Right? So the terms are specified. If you go outside of the terms and you're not able to resolve it, then you may end up in mediation. And then another question that typically comes up is, can the seller offer repair credit? So this would be, again, an example, since if the parties use the MAR property inspections addendum, there is no mention of a repair credit in that addendum. If the seller wanted to introduce that or offer that, that would essentially be a new term that the buyer could agree to, right? But that would be a new term or basically a modification of the contract. First-time home buyer, lots of questions about, what is the law? What is the contract? What does the MAR contract actually say about first-time home buyers? So go to paragraph 24, right? So here's the deal with first-time home buyer in the MAR contract. All right, so paragraph A states the general rule. So the general rule in Maryland, and this is just across the board, buyer and seller, is that unless otherwise negotiated in the contract, the cost of any recordation, tax, or any state or local transfer tax shall be shared equally between the buyer and seller. So that is the general rule in Maryland when it comes to recordation and state and local transfer tax. It's shared equally by the buyer and seller. So then the question becomes, well, what happens if the buyer is a first-time home buyer, right? So the general rule, if the buyer is a first-time home buyer under Section 14-104C, is that the entire amount of recordation and local transfer tax is going to be paid by the seller. That's the rule in Maryland, unless there's an express agreement that recordation and any state or local transfer is not going to be paid entirely by the seller. So the general rule for first-time home buyer is that the seller pays. Then you go on to the next sentence. So remember it says seller pays unless there's an express agreement. So you go on to the next sentence. The next sentence is the express agreement, right? So the express agreement, as far as the MAR contract is concerned, is if the buyer is a first-time home buyer, buyer and seller expressly agree that payment of any recordation and local transfer tax are going to be shared equally. So the bottom line here is that if buyer is a first-time home buyer, then they essentially agree to split these taxes, and if they don't want to split the taxes, that's when you include the first-time home buyer addendum. All right, does that make sense? Any questions about that, Jason? It come through at all?
No, not on that.
Okay.
Not yet at least. So,
okay.
There have been a couple of questions on the paragraph 4B. So,
okay.
What about the area 4B that says if both parties do not initial or agree to 4B, the contract is not valid even if all the other terms are agreed to?
Right. So yeah. So essentially the seller has to. So if the offer comes in with paragraph 4B initialed, that has to be addressed, right? So if the seller doesn't want, 4B to be a part of the contract and doesn't address it, then you don't have a contract. Essentially what that language is saying is that if an offer comes in and that paragraph is initialed and the seller doesn't want that paragraph to be a part of the contract, then they have to take specific action to delete it from the contract. And the way to do that is to strike through it and initial it. If they don't do that, then and they, let's say they initial other terms of the contract, then there is no contract. So essentially what that language is saying is that that provision has to be addressed if the offer comes in and that provision is initialed. Does that make sense?
Yeah, absolutely.
Okay.
So there is a question, are the property inspection notice required for any requests as a result of an issue that the buyer wants taken care of?
Okay, so you have the MAR property inspections addendum, and then you have the MAR property inspections notice, right? So the notice is the property inspections notice simply facilitates what's required under the property inspections, or what the parties have agreed to under the MAR property inspections addendum. Now, of course, the MAR has put that form out there, and you should use it because it tracks the property inspections addendum and what the parties' responsibilities are. But of course, they could use another document. But the property inspections notice should be used because it goes along with the property inspections addendum. It outlines, it tracks, the paragraph and so forth. So, buyer essentially uses a notice to indicate to seller or state to seller what items they want the seller to repair. The seller responds on that notice, and then again it facilitates what the parties' obligations or what they've already agreed to in the property inspections addendum.
And then what about when there is a delay in getting a home inspection due to the delay on the seller's part in preparing the home for inspection, and the example is the power or the water is not on?
Okay, so and that's not something that's the fault of the buyer. It seems to me the parties would have to agree to allow the buyer. I mean, if the buyer can't do the inspection because of issues that are not the buyer's fault, then in agreeing to the spirit of the contract, the seller should allow the buyer to move forward, even though the seller held up the buyer's ability to do the inspection. I think since the parties agreed that the buyer could do the inspection, the buyer should have the right to be able to do that if they're being held up because of something that's out of their control.
Okay. And now I have a first-time home buyer question. So if
okay.
If it's a first-time home buyer and you write the addendum that says split 50-50 between the buyer and the seller, does the title company have to split 50-50 all recordation tax and transfer tax, including the seller-only state tax?
It depends on how that is worded. So if the intent is that they split everything, then the wording needs to be made clear that they are agreeing to split everything. Does that make sense?
Yep.
Okay. Any other questions that have come up?
There certainly are.
Okay, okay.
I'd like to keep on moving along for the moment. So.
Okay. All right, so just a little bit about HOA and condo docs. We're working on getting the time frames streamlined. For HOA, the time frame for getting the disclosures to the buyers different than for condo. You get a lot of questions about why are there so many different notices. For example, with the HOA notices, there are 3 different notices. There are 3 different disclosure and transmittal documents. Why is that? It's so confusing. I never know which one to use. The reason there are 3 different notices, 3 different disclosures, is because there are 3 different sections of the Homeowners Association Act. And for each of those 3 different sections, the disclosures are slightly different. So, for example, there is a resale provision of the HOA Act that specifies, well, these are the specific disclosures that are required in a resale. There's a separate section that deals with if it's an initial sale, and then there's a third section that deals with if it's a sale and the buyer is not going to be living in the property. So the notices track the language of the HOA Act. And so there are 3 different sections. So there are 3 different notices because those sections contain slightly different language. So that's the reason for that. So, you know, if it's a resale, then, for example, you want to make sure that you're using the notice for the resale, and you want to make sure that you're using the disclosure and transmittal for the resale. But certainly it wasn't intended to confuse everybody. They are there. They're that way because they track the language of the law, right? The other area that we tend to see a lot of questions is delivering the disclosures to the agent. So is delivery of the disclosures to the buyer agent constitute delivery? And we are of the view that the delivery of the disclosures should be to the buyer, right? So the time frame, buyer's ability to terminate, that time frame does not begin to run until the buyer actually receives the disclosures, all right? Can you deliver the documents via email? Or you want to make sure that you have some kind of confirmation that the buyer has actually received them if you're going to send them via email. All right, so, and that's there. What about broker must comply with the Brokers Act when handling the deposit? So both acts, you know, allow the buyer to get out of the contract. If they haven't gotten the disclosures, what do you do with the deposit? In that instance, if the broker is holding the deposit, both the Brokers Act, both the HOA Act and the Condo Act specify that if the broker is holding the deposit, then the broker has to comply with the Brokers Act, right? So you still would need to get the parties to sign the release of deposit agreement. All right, so that's the deal there. Any questions come up on HOA delivery or anything like that, Jason?
No, not quite yet. So
all right.
I do have I do have one that's come in with regard to data contract acceptance. So,
okay.
It said if the data contract acceptance is determined by the date the last person signed it, not the date of delivery, in cases where there's no verbal delivery and written delivery doesn't occur for 1 or more days, how does that impact the contingencies whose time frames start at the date of contract as of the date of acceptance?
So the date of contract acceptance is the date the last party signs and initials. If they, if they don't sign until a couple of days later, that's the date of contract acceptance. That's the date when the last party signed and initialed. So the time frames for any contingencies will begin to run on whatever date the last party actually signed and initialed acceptance of the contract.
So in essence, the date of delivery could be a different date than the date of contract acceptance?
That's possible. That is possible.
Okay. And that everything would run per the contract as of the date of contract acceptance?
Correct. That's what most of the addenda refer to. They don't refer to the date of delivery. They refer to the date of contract acceptance. So that's the time frame that the parties have to work with.
Okay. I had an interesting question on duress, if you don't mind answering, getting a little off track, which was, how does duress come into play in a contract situation in a pre-foreclosure or a divorce setting, something like that?
So in a foreclosure or divorce scenario, well, in a foreclosure situation, I think it's a little bit, you're throwing in a little bit of law, you're throwing in other law there. You're throwing in the foreclosure requirements under Maryland law and, the mortgage and the deed and all that stuff. And so, if the seller doesn't pay the mortgage and the property goes into foreclosure, for example, then the foreclosure laws kick in. And so that's a little bit of a different scenario. That wouldn't necessarily be a duress scenario because there are other laws, the deed, the mortgage, whatever, allows the lender to come in and institute proceedings to take the property. With a divorce situation, again, you have the introduction into the scenario of a court, because if they file for divorce, then you have the court that's probably in play there, and they are pretty much kind of detailing, if there's any property involved in the divorce proceeding, how that's going to go. And of course, the court has ultimate authority. They can compel, husband and wife to sell the property. So that wouldn't necessarily be an example of duress. Maybe the best example of duress probably would be, somebody assigning a contract with a gun to their head, something like that. But these scenarios where you have other introduction of other laws, or you've got other documents, agreements that come into play, that's a different scenario. Does that make sense?
Yeah, absolutely.
All right. What about multiple offers? Can a licensee shop an offer? Can a seller? So just a little bit. I'm not going to spend too much time on that because that's more of like a code of ethics thing. But licensees under Maryland law are required to be fair and honest, right? So we've interpreted that to mean that licensees may not shop offers. And just to be clear, shopping offers just simply means disclosing the terms and conditions of an offer. So let's say you've got two buyers who are interested in purchasing the property, and the licensee discloses the terms and conditions of buyer A's offer to buyer B. That's an example of shopping offers, and because real estate licensees are obligated to treat all parties fairly and honestly, it's our opinion that licensees may not shop offers. Now, of course, sellers are not bound by the Brokers Act, so what can they do? Well, they can do what they will do, but for our purposes, licensees, it's our view that they are not allowed to shop offers. Just a little bit about the default. We talked a little bit about breach. So, if the buyer breaches the contract, then paragraph 33, if they use the MAR contract, allows the seller to retain the deposit provided both parties execute a release deposit agreement. If the seller defaults, the parties must mediate, and if there's no resolution, then the lawsuit, either party can file a lawsuit. So paragraph 33 just talks about a default. What happens, if one party breaches, then they can pursue contract damages or specific performance is essentially what that's saying. And the deposit needs to be dealt with in accordance with the deposit provisions of the contract. Just a little bit about mediation. So anytime there's a dispute that arises out of the contract, whether it's deposit dispute or dispute over time frames, what have you, the parties have agreed via paragraph 34, if they use the MAR contract, they've agreed to mediate that dispute, or at least attempt to mediate that dispute. And if they're not able to resolve the dispute, then they have the option of going on and filing a legal claim. All right, so the mediation provision requires at least the attempt at mediation of the parties. If they don't resolve it in mediation, then they could go to court. All right. Just a little bit about computation of days. Just a takeaway here is to remember days are measured from 12:01 a.m. to and including 11:59. The other important point about computation of days is that the count of days begins on the date following the day on which any act or notice is required. So let's say the date of contract acceptance is today, November 5th, 2015, and the buyer has 10 days to do the inspection. That 10-day time frame count will begin tomorrow. Okay, so the count of days begins on the date following the day on which any act or notice is required to be provided. What's the difference between a notice of termination and a release? All right, so there are some instances in the MAR contract where one party can terminate the contract. And take an example. Let's take the financing provision. So the financing says, if buyer does everything they're supposed to do and ultimately they're denied financing, then they can send a written notice terminating the contract and accompany that with a copy of the denial letter. So the way that they would accomplish that termination, they could use the unilateral notice of termination, and they would state, initially that they're the buyer, that they are terminating the contract under their right under the financing provision, and then they would sign that unilateral notice of termination, and they would date it, and then they would send it, and that would constitute a unilateral notice of termination. the key there is that it doesn't require the other party's signature. Right? So that would be an example of unilaterally terminating the contract. Of course, the parties could mutually agree to terminate the contract, and if that's the case, then they would execute the mutual release of obligation under contract. And both parties would be required to sign that and execute it and date it, and then the contract would effectively be terminated. The release deposit agreement is obviously, if the transaction falls apart, then the parties must execute a release deposit agreement in order for the broker to disperse the deposit. And of course, we already talked about the broker has some other options. Let's say seller or buyer doesn't want to sign that. Then there's the 30-day letter, which we talked about. The broker also has the option of filing an interpleader, or of course, they can hold the deposit in the account until the parties actually do reach a resolution. Just a couple of miscellaneous issues, and then I'll wrap up. Can the contract of sale change the compensation offered by the listing broker? So the answer there is that would be a violation of the NAR Code of Ethics. You're not supposed to use, according to the NAR Code of Ethics, you're not supposed to use the terms of the contract of sale to try to modify the offer of compensation from the listing broker. Right? So that's a potential Code of Ethics violation. What happens is the listing broker reduces the commission after an offer has been submitted. Again, we're looking at a potential violation of the Code of Ethics. Because remember, once the offer is out there, once the offer has been submitted, the listing broker can't unilaterally try to change the offer of compensation. And they can maybe arrive at a different arrangement, but they can't unilaterally change the offer of compensation. All right. So that's all I have. Jason, did you have any other questions that had come in?
We do. We have quite a few. So
okay.
I guess we'll just get started with some of those. So does a buyer's agent have the right to refuse to provide a financial information sheet if the seller requests it when an offer is presented?
Does the buyer agent have the right to refuse to provide a financial information? So this gets to the issue of what is the seller directing the listing agent to do. So if the seller is requesting that the buyer submit financial information sheet, and that's in writing, right? That's got to be in writing, and it's got to be, if the seller doesn't want to look at any offers that don't include financial information about the buyer, that should be in writing. And if that's in writing, and an offer comes in that doesn't contain the financial information sheet, as long as the listing agent has that in writing that the seller doesn't want to see any offers that don't include it, then they wouldn't have to present the offer. But it has to be in writing. Whatever the instructions are of the client, especially when it comes to presentation of offers or counteroffers, it needs to be in writing and specifically basically say, look, I don't want to see any offers that don't include this or don't whatever the seller wants. Does that make sense?
Mm-hmm. Yeah. Okay. There is a question here on unauthorized practice of law. It says, if we have someone on our who works for us that graduated from law school but is not currently barred, can they make changes in a contract?
Not as an attorney, no. I mean, unauthorized practice of law, you have to be a licensed attorney in Maryland, in order to, provide legal services. So if you are not licensed as an attorney in Maryland, then you cannot provide legal services. Okay.
Mm-hmm. Okay. What can buyers do if the seller changes the appliances or chandeliers from those that were originally in place when the contract was written?
So the items, the items that I think that's paragraph 13 or whatever that talks about the inclusions. And remember, the parties are agreeing to have the seller or convey the property, under the terms and conditions that's specified in the contract. So if the parties agreed that the seller would convey the property with this particular refrigerator and that particular chandelier, and the parties agreed to this, and the seller removes that stuff, then that could be an issue. You know, if there are specific things that the buyer wants the seller to convey, they need to state it in writing. I want this, you know, refrigerator, I want this fixture, whatever it is, needs to be specified. And then that way, if it's not conveyed, then the buyer has the argument that, you know, the seller, you know, essentially is breaching breaching the contract. So whatever items the buyer specifically wants, they should be identified so that there's no confusion, so that, you know, if the seller tries to switch something out, that's sort of dealt with.
Okay. Here's a good one. What is a commitment?
What is a commitment? We say it's whatever the lender says is a commitment, right? I can tell you that the Statewide Forms Committee has grappled with trying to define what a commitment is. I know at one point they had, you know, various lenders come in to try to provide some clarity to that provision. But at the end of the day, you know, in 2015, any commitment is going to have a ton of conditions that must be satisfied before the loan is ultimately, you know, approved. So it's essentially whatever the lender says is a commitment.
Okay. And then there on your slide it had said who can declare the contract null and void under paragraph 10, and they wanted a clarification of the financing. Okay,
so the paragraph 10 of the financing provision, let me just pull that up, essentially says that, you know, it's the financing contingency. And so it says, the second sentence is really key. It says, if a written financing commitment is not obtained by buyer within the time frame specified, so either buyer or seller has the ability to terminate the contract. So if the written financing commitment is not obtained within whatever the time frame is the parties agree to, the seller could send a written notice terminating the contract, and buyer could as well. So buyer did everything they were supposed to, they were ultimately denied, and they could submit a notice of termination as well. It would be accompanied by a denial letter from the lender. So either party under the financing contingency has the ability to terminate the contract.
Okay. A couple of lead paint questions. So,
okay.
Is the federal lead-based paint form required if the home was built after 78?
The federal lead disclosure is not required if the residential property is constructed prior to 1978. And that, you know, the contract specifically says that, right? There's a lot of confusion about that. But if you look at the contract, paragraph 16A, right, it says section 1018, title 10, requires disclosure by seller of information regarding lead-based paint and lead-based paint hazards in connection with the sale of any residential real property constructed prior to 1978. The law applies to residential property constructed prior to 1978. Okay.
And then I have a rental home built in 78. Do we still need to file a lead environment with the Maryland Department of the Environment's filing?
It's prior to 1978, so now go down to the Maryland Lead Poisoning Prevention Program Act, right? So it applies to any residential dwelling constructed prior to 1978. So we're talking about 1977 and before. So if the property is constructed in 1978, then the program doesn't apply, okay? But if the property were constructed in 1977, the program would apply. The property would have to be registered with the Maryland Department of the Environment.
All right. A latent defect question, a little bit of disclosure coming now. So is not having permits for an addition a latent defect?
It depends. It's likely a material, well, I should say, it may be a material fact, but the question of whether or not it's not having permits is a latent defect, well, it depends on whether or not the work was done properly, right? So the work was done properly, even though you don't have the permits, it may not be a latent defect, but it's probably going to be a material fact because, you know, anybody who buys that property and has work been done without the permit, they're going to have to go through the county or city to have that, you know, get to rectify that. So it may not be a latent defect. Now, if the property, if the repair was done or the rehab work was done defective, then it may be a latent defect. So work done without a permit and you know about it, pretty much going to be a material fact. You have to disclose it. Whether or not it's a latent defect, it depends on whether or not the rehab job was done defectively or not.
Okay, and I think that answered this question, but we'll just be clear. Are listing agents required to disclose material facts that may have resulted in the cancellation of a prior contract on the same property, for instance, under the home inspection results?
Yes, so if the transaction falls apart due to, you know, the buyer's dissatisfaction with the home inspection, and the report contains information that could constitute a material fact, then the listing agent would need to disclose that the report was done, that the inspection was done, that an inspection was done, and that an inspector, it is an inspector's opinion that these are the issues, right? So yes, you know, the information that's contained in that report, it would need to be conveyed to subsequent buyers that there was an inspection done and that it's the opinion of a particular inspector that these issues, there are these issues with the property.
Okay. Going on to a little practice of law question.
Okay.
Is it a best practice to review the contract forms with the client paragraph by paragraph, or could that be seen as practice of law?
Well, remember, you want to, you remember you have a fiduciary obligation to protect and promote the client's interest. So, you know, I think you can discuss the terms of the contract and, you know, what your experience is as a real estate licensee, and you're discussing the terms of the contract. I think that's okay. Obviously, if you're giving a legal advice, then that, I think, is a little bit different. But I think, you know, as a real estate licensee, I think you can, you know, discuss with the client, you know, the terms of the contract, as long as you're not giving legal advice. I mean, there could be, I guess, a gray area there. But yeah, I don't think there's anything wrong with doing that.
Reviewing, yeah. Okay. Recently, a seller agent refused to return all 4 pages of the disclosure disclaimer. What recourse does the buyer have?
The seller
Does the seller agent refuse to return all 4 pages of the disclosure disclaimer?
Well, so did the buyer not get all 4 pages of the disclosure?
Yeah, that's what it sounds like.
So if the buyer did not get all 4 pages of the disclosure, I think the argument can be made that the buyer didn't get a completed copy or a complete copy of the disclosure disclaimer statement. And so until they do get a complete copy of the disclosure disclaimer statement, they have the ability to terminate the contract.
Okay. Once a contract's in default and the contract is declared void, so I'm assuming that means by both parties, can the non-offending party still sue for damages?
as long as they're not giving up the right to sue, right? So as long as the seller, let's say it's the seller, they want to sue the buyer for contract damages, as long as they don't execute anything that says they are relinquishing their right to pursue damages or legal claims, then they can pursue legal claims.
Okay. How about if a listing agent receives an offer from a co-op broker with 6 addendums, but only 3 of them are checked off in the contract as included?
Okay, so then what, the 3 addendums, that's, would seem to me, if the 3 addenda, and they're, I guess what, they're blank or they're not, they don't have any, they're not initial or anything?
To me, I'm reading it as there were 6 separate addendums that were included with the contract, but there was a failure to identify 3 of those that were included as part of the contract in that paragraph 17 of the contract that tells you their disclosure are going to be included. So.
Oh, okay. So they're there, but they're not specified in paragraph 17.
Yes.
Well, I mean, obviously the best practice is to make sure that everything lines up, and so if there's 6 addenda, then it should reflect that in the contract. I mean, I think ultimately, though, if the parties initially sign off on everything, then maybe you might still have a contract, but there could be an issue there.
Okay. Let's see. Another disclosure question, so give me 1 second here. I guess there was a question, and it'll be a little more general, and so I guess to be brief, but can you touch just briefly on short sales?
Okay, touch briefly on short sales. Well, I will say this: the short sale addendum or a short sale transaction should be treated like any other contingency. So if it's a short sale contingency, it should be treated just like a financing contingency. Or a home inspection contingency. I mean, typically one of the issues that comes up with the short sale situation is, well, is there a contract? Is there not a contract until the lender approves it? And so the answer there is you actually have a contract when the seller accepts the offer. The contingency is, or the condition of the transaction actually settling, or the contract actually settling, is the lender's approval. So short sale should be treated just like any other contingency. You want to make sure that the parties, are clear about what the terms of the short sale addendum are. You want to make sure that if you're using, if the parties use, for example, the MAR short sale addendum, that there's a time frame for third-party approval inserted. And again, it should be treated just like any other contingency.
Okay. There was a question regarding legal description. Am I correct in what I've been advising that the best legal description is the tax ID and LIBOR folio assigned?
Well, it depends. I mean, the MAR contract doesn't have that, right? It's got a description, the address of the property, right? I believe there was a time when the contract did have all of that additional information. But I think for residential transactions, the address of the property is probably okay. Now, you may need that information if you're dealing with unimproved property. But as far as I know, I'm not aware of any issues that have arisen with the property description being the address in residential transactions.
Okay. I believe that we have covered most of these questions then in one form or another.
Okay.
So I think that we're pretty good here. I guess I would simply say if anybody had a question that they got in that wasn't answered, that they could certainly contact the legal hotline.
Yes, absolutely. You could contact the legal hotline. You could submit your question. Go ahead and submit your question through the email. The hotline is open tomorrow between 10 and 12 and between 2 and 4. But you can still go ahead and submit anything that comes in through the email hotline. That's now. So if we didn't get to your question, or I didn't get to your question, then please feel free to go on the MAR website and submit your question via the email, and we'll answer it as soon as possible. Okay. But I do want to thank everybody for listening to the Contracts 101 webinar. Have a great Thursday. I want to thank you, Jason, for facilitating the questions, and everybody have a great Thursday. Thank you very much.
Colette, before we go, there's been some question as to whether we're going to make your slides available afterwards along with the recording of the webinar.
Yeah, well, I suppose we can. I don't have any objection to it.
Okay, as long as you're okay with it. What we'll do then is we'll go ahead and post the slides along with the recording once we've posted that to the webinar, and then let everybody know via email that it's been posted. And again, if you had any questions that were not addressed, please email those directly to the legal hotline, and we appreciate your time today. Have a great day.